Good evening, everyone. Welcome to class. We have sorted out the hardware issues that were persistent yesterday, and there shall not be a problem. And I hope all of you are having the stamina to sustain a 2 hour class. I understand that some of you may have had an evening GS class and an optional class as well. So don't worry, you don't have to write anything in today's class. Just understand what's going on, and the notes have been given to all of you. Right? Good evening. Right. So let's start our discussion from where we left off yesterday. What we were discussing yesterday, where there was a slight amount of a technical issue, was the issue of amenability or the legal status of fundamental rights. We had understood that whether it is a fundamental right or a directive principle or a fundamental duty, all the three of them can be amended through a constitutional amendment under Article 368 without state ratification, which means a special majority 2. This also means more than half of the, more than 2/3 of present and voting in such a way that it is more than half of the total strength of the House. Right? So we understand that. Now we will continue with our class and we will understand the amenability portions. We figured out the amenability portions. We are going to understand the enforceability of what is called directive principles, rights and duties. Right? So as we were trying to understand this, I'll pick this up from yesterday. So we were talking about fundamental rights. We were talking about directive principles of state policy, and we were talking about fundamental duties. And we had understood that when we talk about enforceability or when we talk about implementation of it, we're looking at the three branches of government: the legislature, the executive, and the judiciary. And what do we understand out of the three is what we're going to be getting into. Right? So we also remember from our discussion in the preamble legal status that enforceable by a court means the same thing as enforceable by a court means the same thing as justiciable. Enforceable by a court means the same thing as justiciable. We'll come to that. We've discussed this before. So as we were discussing yesterday, can the fundamental rights be implemented by the legislature? Can they be enforced by the legislature if they want to? Absolutely yes, no problem at all. Can the executive make a scheme, pass an order in the context of a fundamental right to implement or to uphold a fundamental right? Absolutely yes. Now comes the enforceability by the judiciary, or the other word that we use for enforceability by the judiciary is justiciability. So let's look at some specific components. This is usually not asked in the exam because the legislature and the executive can literally do anything they want to, as long as it doesn't violate the ethos of the constitution. And if they do, it is actually the judiciary that looks into the legality of the matter. So let's look at some specific outcomes. Say outcome number 1. Can a law made by the legislature be challenged in the judiciary? Yes, absolutely. Can an order which has been passed by the executive challenged in the judiciary on the grounds that it violates fundamental rights? Absolutely. No question at all. This is unquestionably true. Right? And can the judgment be given by a court on the basis of a fundamental right being violated? Absolutely. Absolutely. Right? So as far as justiciability is concerned, fundamental rights are right up there, right on top. Like for example, the legislature decides to pass the Right to Education Act in order to further implement Article 21A, which asks the Parliament to make a law giving details on right to education, which is under Article 21A. Similarly, the executive introduces the midday meal scheme, the Sarva Shiksha Abhiyan, which today has been converted into the Samagra Shiksha Abhiyan as an umbrella scheme on school education. So we covered that part as well. And at the same time, if a law or an order which has been passed by the legislature or the executive, can it be challenged in the courts because it's violating a fundamental right? Absolutely. Absolutely no problem at all. Absolutely. And can a judgment be given by a court which violates on the grounds that something is violating or on the grounds of fundamental rights? Absolutely. Even the judgment of the court cannot violate a fundamental right per se. Right? So that is something we understand. Now, let's look at directive principles. Now, when we look at directive principles, we understand, can the legislature, if they want to, can they make a law to implement a directive principle? Absolutely yes. Absolutely yes. Can they pass a scheme or can they issue an order to uphold a directive principle? Absolutely yes. No problem at all. Now comes the difficult part. The difficult part is, if the government does not implement a directive principle, can you take the government to court? You absolutely can't take the government to court. This is a strict no. Not at all. If the government is making something or the other, absolutely no problem at all. Okay, all right. Okay, so don't worry about it. Now, so that is that. Okay. Uh, Now, let's come to the next part. Let's come to the next part. Let's understand what it is that we are talking about. Right? Now, can, for example, the government, if there's a scheme or if there's an order that has been passed by the government and it is not, while it's not implementing a directive principle, or a scheme or an order is violating a directive principle, so can you take the government to court for it? No. Whether it's a law or a scheme or an order, if it's violating a directive principle, then you can't take the government to court just because it's violating a directive principle. So that's something we must understand, right? Can the court give a judgment on an issue saying that this issue is ruled in favor because a directive principle is being violated? No. Not only on the grounds of directive principles. We will remember the plus X principle. It has to be directive principles and something else which is enforceable. So it's a clear cut no. Right? Now, as far as fundamental duties are concerned, let's understand this as clearly as we can so that we know exactly what we are referring to. Right? Now, see, this is something important. Though the implementation or none of the fundamental duties mentioned, like how we were talking about executory and self-executory rights, we were talking about all of this. There's nothing called a executory or a self-executory right. So there is absolutely no compulsion on the legislature. It's not defined at all. So we don't have to worry about it at all. But if the government wants, they can make a law on a fundamental duty. Like, for example, one of our fundamental duties is to, respect the national anthem, the national flag. Now, that is more than enough. But the government makes a law which says Prevention of Insults to the National Honours Act of 1971. The government could have made that law irrespective of whether it was a fundamental duty or not. It does not matter. There is absolutely no compulsion on the government to make a law on fundamental duties, and there's absolutely no compulsion on us citizens to compulsorily follow fundamental duties. In fact, there are several scholars who say that, fundamental duties must be made enforceable. If you're giving rights to people, then people also have an obligation to perform duties compulsorily. It should be a two-way street, right? And then, of course, when we talk about the executive, again, if the government wants to make a scheme or something on it, yes, of course, you can. But now the question is about justiciability. So, if, for example, a citizen or anybody is violating a fundamental duty, can you take the citizen to court? The answer is an absolute no. The answer is an absolute no. Okay, the answer is an absolute no. Correct? Are we clear on this? Do we understand this as clearly as possible? So this is something that we are referring to. For example, the government has not only made like an ordinary law, the government has actually made a constitutional amendment to implement a directive principle which talks about organization of village panchayats, right? And they've also made an ordinary law called the Panchayat Extension Scheduled Areas Act. So the government can, and the government is absolutely free to do what it wants to in the course of this. They've made, the several schemes to uphold Panchayati Raj, to promote Panchayati Raj, several where you're incentivizing states on how well they're performing on Panchayati Raj indicators. So there are so many ways that you could implement it. The UPSC will only and only ask you this much, and here also they will ask you this and this, the most importantly. Everything else here is very subjective in nature. There are no defined answers to this. And this is all up to the will of the government. Okay, so don't worry about this too much as far as the exam is concerned. So as far as enforceability and amenability is concerned, this is more than enough to deal with whatever we have to in the context of whatever we need to, right? So this takes care of the legal status as much as we need to. Now, let us take a magnifying glass and now spend some time on the classification of rights and not just fundamental rights. Yesterday we discussed that rights can be executory or non-self-executory. We discussed how fundamental rights, some of them are available only for citizens, all of them are available for citizens, but only some are available for foreigners as well. We also discussed there are a few rights which are enforceable against private institutions as well. So we've covered all of those things, right? But we are now going to focus on the classification of rights. And this is where I will remind you of what I said in the very first minutes of yesterday's class, where I told you there could be three truths in life: your truth, my truth, and UPSC's truth. And what really matters is the truth of the UPSC. What they think is the right answer is what the right answer is according to us. And how we know what the right answer is? If we are able to see the kind of answer keys that they've given for the prelims questions that they ask on a year-on-year basis, right? So we will be able to we'll be able to now look at a larger discussion on the types of rights. On the types of rights. Okay. Why are there so many sirens? Just 1 minute, please. Okay, it is now silenced now. So, there are basically three kinds of rights as far as you and I are concerned. First, we have fundamental rights. Then we have constitutional rights. And then we have what are called statutory or legal rights. As far as our UPSC is concerned, we will assume statutory rights and legal rights to mean more or less the same thing. They can be used interchangeably. Alright? Now, let's understand the difference between the three as far as our exam is concerned. Of course, if you are a political science student or a sociology student, right, in such a scenario, you will of course, will study the theory of rights, the theory of natural rights, the theory of human rights, the theory of animal rights, spiritual rights. But we are in the business of the law. A right is only a right for us if the right is available to us. A natural right or a human right are excellent discussions to have in the context of political theory, but as far as you and I as students of the law is concerned, we only need to concern ourselves with a fundamental right, a constitutional right, and a statutory or a legal right, because a right is only a right if it is being given to us, if there is some form of a law which guarantees us the accessibility to a right. There is an enforcement mechanism to that right. There is a redressal mechanism to that right. And only when that is the case, and only when that is true, is the right important, right? We are talking very practically. This is a very practical discussion, right? So let's understand this, right? Okay. They also came to study about fundamental rights. I don't think VIPs in our country worry about fundamental rights for obvious reasons, right? Okay, now let's understand this. No, I'm at home. This is where I live. I'm at home. This is a home studio setup, right? So let's continue. Let's understand this. So, what are fundamental rights? Fundamental rights are rights which are available in Part 3 of the Constitution of India. Okay, only those rights which are under Part 3 can be called fundamental rights. Everything else, doesn't matter if it's in the Constitution or not, cannot be called a fundamental right. A constitutional right, on the other hand, is a right which is in the Constitution, but not under Part 3. It could be under Part 1, 2, 4, 5, 6, 7, 8, 9, 10. That is okay, but cannot be under Part 3. And a statutory right or a legal right is a right which is a right available under any law other than the Constitution. Under any law other than the Constitution. Okay? Now, let's understand this. For example, let us say the right to equality is a fundamental right that is being guaranteed to all of us. It is a fundamental right because it is under Article 14, which is under Part 3. Okay? But the right to property, which was previously a fundamental right but is today a constitutional right, it is a right under Article 300A of the Constitution. Similarly, the right to vote. Now, this was a little bit of a gray area kind of a question, right? It was a gray area kind of a question. Thank you, Ankit. I really appreciate it. Thank you. Now, the right to vote. Now, this was asked in one of the previous year questions. The right to vote is a constitutional right because it originates from the articles pertaining to Universal Adult Franchise and the Election Commission 324 onwards. So, according to the UPSC, the right to vote is a constitutional right. The right to vote is a constitutional right. It's not a fundamental right, and we have a separate legislation called the Representation of People's Act. Now, the Representation of People's Act does give you certain qualifications and disqualification to conduct elections, to contest elections. It also gives you a list of electoral offences. All of those things are there. But the right to contest elections originates from the Constitution, not from the Representation of People's Act, as per the UPSC. Now, outside the circles of UPSC, there can be arguments on either side. But we have to be very clear on this, that UPSC says right to vote is a constitutional right. So, right to vote is a constitutional right. End of discussion, end of story, right? Now, legal right. For example, your consumer rights under the Consumer Protection Act is in fact a legal right. And there was a trick question. So in 1 year, UPSC asked, what is the right to vote? It gave you options. The answer was, of course, constitutional rights. But a few years later, the UPSC had also asked, what about the right to vote and contest elections? So the right to vote plus contest elections is actually a statutory right under the Representation of People's Act. Okay, because the Representation of People's Act gives you disqualifications, gives you abilities, gives you the procedure as to what is it that you're supposed to follow as far as contesting is concerned. The Constitution, now you must understand this, the Constitution, and this is important, the Constitution, right, as far as vote and contest is concerned, the Constitution gives you the eligibility for which you can become an MP or an MLA. But that does not necessarily give you the right to contest. The right to contest, as per the UPSC, is Representation of People's Act. Okay, now Nishant is asking, the right to freedom of movement of goods throughout the country is classified under what right? Now this is freedom of interstate trade and commerce. So if you're looking at interstate trade and commerce in terms of movement of materials and can it be taxed, it's a constitutional right. But it could also be looked at it from a fundamental right perspective, because if you have the ability to trade or to practice any profession, and if the business that you're in wants you to travel your goods, so it could be in other parts of the country. But if in the prelims they ask you the freedom of movement of goods from one state to another, is that explicitly a fundamental right? The answer is no. You could probably look at it as a constitutional right if the need might be. Alright, so that's okay, we'll come to that later. But in practice, in reality, the two most important constitutional rights, and perhaps the only two major constitutional rights that we refer to, are actually what are called the right to property and the right to vote. Okay, now as far as amenability is concerned, as far as how can they be changed is concerned, it's again a very interesting discussion, and we're able to understand that a fundamental right can be amended through a constitutional amendment under Article 368 without state ratification. This is absolutely clear on this. And as far as a statutory right is concerned, a statutory right is under an ordinary law, and all ordinary laws require only and only simple majorities to be passed. If you want to introduce a new right or remove an existing statutory right, it will always be recorded here, right? Now, it's that simple. It's the law which is giving you this right, not the Constitution. So as long as the law exists, the right exists, right? Now, the problem here is with constitutional rights. Now, very interestingly, when we look at the right to property or when we look at the right to vote, it is again not mentioned whether it is an amendment which requires state ratification or whether it is an amendment which will require, will not be considered an amendment in the first place. So we generally presume that constitutional rights will also be amended in the same manner as Article 368 without state ratification, right? Without state ratification. even if it is the right to freedom of interstate and commerce, because the center has the right to regulate interstate trade and commerce. And that is exactly why the center had the powers to also introduce the farm laws, despite the fact that agriculture was in the state list, because the farm laws were not about agriculture per se, but it was about the movement and the business of agriculture, which the center can regulate under the union list. Anyways, so this is how either of the three can be amended. Now, and we will do this in a fair amount of detail. And please pay attention. If a fundamental right is violated, then a person has two choices. Under Article 32, the person can directly approach the Supreme Court as the first court. You can directly go file a case in the Supreme Court and no problem at all. And you also have the option to go to the High Court, which is in the state where your right was violated. So it is not that you can go to any High Court, you will go to the respective High Court. You will go to the respective High Court where the incident happened, or where you want the law to be challenged. But like for example, if we are challenging a law, if a law has been passed which violates a fundamental right, you can challenge that law both in the Supreme Court as the first court, or you can challenge that law in the High Court as well. Now the law is uniformly applicable, so it doesn't matter which High Court you're filing the case in, it does not matter. But if a specific incident has occurred, then you will have to go to the High Court of the state where that incident has occurred. But that's again too much of technicality. What you basically need to understand here is that if a fundamental right has been violated, then under all circumstances, you have two choices. Choice number one, you can directly go to the Supreme Court. Choice number two, you can directly go to the High Court. If you get an unfavorable decision from the High Court, you can, of course, you are entitled to an appeal to the Supreme Court. Nobody is denying you that. But as a person whose right has been violated, whose fundamental right has been violated, you have the option to either directly go to the Supreme Court or directly go to the High Court, and that is entirely up to you, no problem at all, and nobody is ever going to stop you for that and worry you for that. Okay, so I hope this is clear. I hope you understand this, right? I hope this is clear. So as a person, you have the absolute right, whether you are whether you want to go to the Supreme Court or you want to go to the High Court, you have the absolute right to decide which court you want to go to. Okay, so that's the basic idea, and that's the basic understanding of the enforceability or the mechanism of how fundamental rights can be enforced. Okay, now let's look at constitutional rights. Okay, now let's look at constitutional rights. Now, as far as constitutional rights are concerned, very honestly, there is absolutely no procedure given. It is not defined at all in the Constitution. Nobody says this is the court that you will go to if your right to property has been violated. But if your statutory or your legal rights are violated, then in that scenario, you can't go to the Supreme Court directly. You can't go to the Supreme Court directly. You can directly go to the High Court. You can directly go to the High Court. Okay, and you can go to the High Court under Article 226, which is, say, a counter provision to Article 32. Alright, so that is something that we must understand, that is something that we deal with, and that is something we must be okay with. So our basic understanding is, if my fundamental rights are violated, it is my choice. I can go to the Supreme Court or the High Court directly. If my statutory rights are violated, I can go to the High Court directly. I can't reach the Supreme Court. That means we are in the dark as to what we should do in case our constitutional rights are violated, in case our constitutional rights are violated. So what ends up happening is that a constitutional right, in one way, the Constitution is also a law, and if a law is giving you a right, so in jurisprudence it can also be like a legal right. So which is why in ordinary cases, if your constitutional right needs to be enforced, you would most likely take it to the High Court. Which is why we often say that constitutional rights are similar to legal or statutory rights in the perspective of their enforcement. That which court that you can go to, from that perspective, a constitutional right and a legal or a statutory rights can be considered to be similar. All right. So we assume that we could go to the High Court, and the High Courts usually entertain the matter accordingly. Right. Now let us spend some time on this, because this is actually very interesting. So what we are seeing here is that you can directly go to the Supreme Court. You can directly go to the Supreme Court, in case of a fundamental right violation only. In case of a fundamental right violation only. You can go to the High Court directly for both fundamental rights and legal right violations. This means, Himanshu, don't stop me in the middle of a class to ask a random doubt that I haven't even covered yet. Let me get there. This is not a personal tuition. This is highly objectionable. Your behavior is extremely objectionable. There are more than 1,000 students in the class here. I am not your personal tutor. So learn to behave yourself. Alright, anyways. So let's focus here. Which means that the High Court can look at larger number of rights cases as the first court than the Supreme Court. Which is why we say that the High Courts have a wider jurisdiction. The High Courts have a wider jurisdiction than the Supreme Court when it comes to enforcement of rights, because the High Courts can look at a larger variety of rights as the first court, or as the court of first instance, right? Okay, understood this? Now, some of you should find this objectionable, because in our golden rules, we've studied something called rule number 2, and rule number 2 clearly starts with center stronger than the states. And we understand that the High Court is the highest legal or the highest judicial authority of the state. So why are we giving a state's highest judicial authority more powers than the country's highest judicial authority in terms of the number of rights that it can look into? But if you look at it carefully, this actually is not going to violate rule number 2. And you must understand this, because firstly, the reason why the High Courts become the courts of first instance for both of these rights is because this helps in reducing Supreme Court burden immensely. That's one of the key reasons why we would do this. Reducing Supreme Court burden immensely. Second, and this is also an equally important reason, all cases from the High Court, if one of the petitioners is unhappy, can go on appeal to the Supreme Court anyway. The third reason is the Supreme Court judgments are unilaterally applicable on all High Courts. There are no two doubts about it. And the fourth reason is that while we are giving the High Courts these extraordinary powers, and while I understand that the High Courts are the topmost judicial authorities in a state, the state government, and in any role whatsoever, the state government in any capacity whatsoever has absolutely nothing to do with either the appointment or the removal of judges. The appointment or the removal of judges. The state government has absolutely nothing to do with the appointment or, in fact, the removal of judges. Right? So, this is something we must understand. This is something that we must be okay with. So, this is actually a candy that we are giving the states, that you know what, your high court is going to get a larger number of rights that it can look at, while you have no role in choosing who your high court judges are going to be. Okay, now, so how is a fundamental right violated? How is a fundamental right violated? There are multiple ways. First, there might be a law. This may be a central law or this may be a state law, and either the entire law or certain specific provisions of the law may be violating a fundamental right. Right? That's one of the ways to go about it. Second, again very interestingly, this could be an executive order, any order issued by a ministry, anybody in the government, which could violate your fundamental rights. So any executive order, any decision taken, this could be from the center or the states, this could essentially violate your fundamental right. There has to be some origin to law how this happens. Now let's apply these two principles in real life. So, whether it is a central law or a state law, if that law is violating a fundamental right, we can challenge the constitutional validity, we can challenge the constitutional validity of the central or the state law at both the Supreme Court or the High Court? Absolutely. If the Supreme Court declares the law or a provision unconstitutional, it cannot be applied to the whole country. But if the High Court declares that law or a provision of that law to be unconstitutional, then it cannot be applied to the state to which the High Court belongs. Okay, this is how it is done. Like for example, and I'll teach you this in detail later, two of our earliest judgments on sedition actually came from the Punjab and the Haryana High Court and the Allahabad High Court. The two earlier decisions on the constitutional validity of sedition, whether it is violating Article 19 of the people or not, in the earlier two judgments before the 1960 62 Kedarnath judgment, both of these high courts, the Punjab Haryana High Court, and they had a single high court for Punjab and Haryana, and the Allahabad High Court had actually declared sedition unconstitutional. So till about 1962, no case in Punjab or Haryana and no case in Uttar Pradesh could be filed at a police station on the grounds of sedition, right? But the Supreme Court declared Section 66A of the IT Act. Section 66A of the IT Act unconstitutional. That means nowhere in the country can a complaint or an FIR be filed on grounds of Section 66A. Okay, on grounds of Section 66A, right? So that is something that we must understand. So if in the prelims they can ask you a confusing question. They can ask you, can the constitutional validity of a central law be challenged at the High Court? The answer is an absolute yes. In fact, if you trace the legal history of LGBTQIA movements, the NAS Foundation case, the NAS Foundation had challenged the constitutionality of Section 377 of the Indian Penal Code, saying that it includes homosexuality and it should not. And the Delhi High Court had originally given a judgment that it should not, and then of course the center appealed to the Supreme Court. But for those 3 years, homosexuality was perfectly legal, but only in the state of Delhi. Later on, of course, the Supreme Court in the Navtej Singh Johar judgment, post the Puttaswamy judgment, made it perfectly decriminalized, and all of that happened eventually. But broadly, this is how it is done, right? So we understand how are fundamental rights violated, right? These are the basic ways. Now comes the most important question. The question is, who are these fundamental rights against? And we discussed this briefly yesterday, that all fundamental rights are available against the state, but only a few rights are available against the state as well as private. And this private includes individuals as well as organizations of any nature, right? We've covered this yesterday. But what we need to now focus on is what constitutes the state. What we need to now focus on is what constitutes the state. Now, Article 12, that is from where Part 3 begins. The very first article of Part 3, Article 12, actually gives you the definition of the word state. And I take you to the article so that you understand exactly what we are referring to. So if you could just give me a minute, and I will open the constitution so that it's easy for you to refer the same as well, right? They've just updated it to the 26th of November 2021. So this is an extremely updated PDF and officially released by the government of India. So part 3, fundamental rights. In this part, unless, in this part means, in this part, part 3, unless the context otherwise requires, which means unless it is specifically mentioned, in a general sense, you will assume the state to include the government and the Parliament of India. So this means this means central legislatures and the central executive. This includes the elected executive. This includes the permanent executive. And the government and the legislature of each of the states, So central and state legislatures, center and state executives, elected and permanent executive, and all other local authorities. So this includes local self-government, both urban and rural, or other authorities within the territory of India or under the control of the government, or other authorities within the territory of India, which includes your PSUs, etc., or under the control of government of India. This government of India again means the center. Now, all is great except for one word. The one word which is missing here is judiciary. And the word judiciary has been purposefully omitted by the makers of the constitution. The word judiciary has been purposefully omitted by the makers of the constitution. Everything else is simple. Anything owned, operated, or managed by the government or the legislature is essentially the state. But the one thing which is questionable right now is judiciary. Okay, so what happens here is, when we discuss the state, we must first understand what happens to judiciary. Is the judiciary considered state or not? Now you must understand this. There is something very important. Basically, we will study this in basic structure. After 12 is Article 13, called Article 13 Clause 2, and Article 13 Clause 2 says no law can violate a fundamental right. Okay, we'll keep coming back to this. This is one of the most interesting articles of the Constitution. Now, with judiciary, there is a catch-22 situation. If you don't understand what a catch-22 situation is, मतलब आगे कुआं पीछे खाई. Like it's a difficult choice to make. Now let's understand this. Let's understand why this is the case. All right. Now, if judiciary was state, and we understand that all fundamental rights are available against the state, that means the judiciary will not be able to give a judgment on a fundamental right violation, will not be able to give a judgment on a fundamental right violation. Do we understand this? अगर जुडिशरी स्टेट है और एंड नो फंडामेंटल राइट कैन बी वायलेटेड बाय द स्टेट, तो कल को जुडिशरी के पास एक केस गया कि देखिए ये फंडामेंटल राइट वायलेट कर रहा है या नहीं, और जुडिशरी ने कहा कि नहीं कर रहा है, तो इसका मतलब जुडिशरी ने आपकी फंडामेंटल राइट उखाड़ ली. डू यू अंडरस्टैंड दिस? सो दिस इज अ वेरी डिफिकल्ट सिचुएशन. If the judiciary is considered to be state and all fundamental rights are available against the state and no law can violate a fundamental right, then the judiciary cannot give a judgment on a fundamental right violation. Right? Understood this? Does not include, right? Of course it doesn't. Okay? Of course then it will be a problem. Then a judgment cannot be given on a fundamental right violation. An extremely important question to be asked. And if the judiciary is not the state, that means the judiciary is over and above fundamental rights. That means the judiciary can violate any fundamental right they feel like. Right? They can violate any fundamental right they feel like. Which is why there must be a solution to this. There must be a solution. I hope you understand this problem. I hope you understand why this is a sensitive situation. I hope you appreciate the contradiction in this problem. Autonomous governments are of course under the state, Raksha. These autonomous governments exist because the government allows them to exist. Clearly understood? Excellent. So therefore, now whenever there is a confusion, we have to go to the Supreme Court. So the Supreme Court, I will come back to this case in detail later. In the Sunil Batra case, we'll come to this later. This is not important as far as the prelims is concerned. In the Sunil Batra case, explained that the judiciary has two components. First, the judicial component, where judgments are given, legal arguments are made, the court's side to judiciary, right? Yes, ठीक है. And the second problem is, and the second element is the administrative side to judiciary. After all, the judiciary is also an administrative organization. How the cases are to be filed, which case will go to what court, how is the judiciary utilizing its funds, and so on and so forth. Right? Now, in this case, the Supreme Court said the judicial side to judiciary is not state, but the administrative side to judiciary is state. It will come in the definition or the broad elements of the state. So let's understand what it is that we are referring to, what it is that we want to get right. इसका actual मतलब हुआ. For example, we understand that right to information is also a fundamental right under Article 19, and right to information is available against the state. So let's understand some basic questions. Can an RTI be filed against the Supreme Court questioning the rationale behind a judgment? I'll give you some options. Can an RTI be filed against the Supreme Court questioning the method through which cases are allocated to courts? Can an RTI be filed against the Supreme Court questioning how the Supreme Court is utilizing funds for enabling e-judiciary? Each of these three questions are going to have very specific answers. The answer to the first question is no, because this is a judicial function. But B and C are administrative functions. So, in B or C, can an RTI be filed questioning कि भाई आप कौन सा केस किस कोर्ट को दे रहे हो, क्या कर रहे हो, क्या करते, कैसे केसेस आप फाइल कैसे लेते हैं? Yes, absolutely. Can you question how the Supreme Court is utilizing the funds? Absolutely, yes. ये हम कर सकते हैं. Can you file an RTI asking the Supreme Court ये जज के पास ये वाला केस क्यों गया? वो नहीं कर सकते. That is a judicial decision. But can you ask how the cases are filed through the registry process? That you can. So judicial questions are exempted, administrative questions are not. So the judicial side to the judiciary is state, whereas the administrative side to the judiciary is not. Is the judicial side to the judiciary is not state, whereas the administrative side to the judiciary is state. This is as per the Supreme Court judgment in the Sunil Batra versus Delhi administration case. Right? Understood this? Yes. Very good. Excellent. Very recently, the Supreme Court also said that the CGI office is also going to be under the RTI. So can I file an RTI to the CGI asking why did you give a judgment in this case? No. But can I file an RTI to the CGI asking अच्छा ये बताओ how are you modernizing Supreme Court infrastructure? That yes, I can do. So that's the basic difference. ठीक है? तो this is how judiciary and this is how the element of the state works and this is how it is. अब इन सब में ना एक बहुत बड़ा क्वेश्चन मार्क है. That question mark is, there is an organization in this country. It is one of the largest organizations in the world. It is one of the most powerful organizations in the world. It officially represents a sector in India. It officially represents a sector in India. It officially chooses Indian representatives in that sector. It not only is the representative of the sector, it is also the regulator of that sector. The organization that I'm talking about is the Board for Cricket Control for India, BCCI. BCCI is entirely privately owned. It is doing exactly what the state does. It is performing actions like the state. BCCI is regulating cricket. BCCI is the official cricketing organization in the country. It also supervises state cricket associations. It is the BCCI who chooses the Indian cricket team. It is the BCCI who is India's face at the International Cricket Council and all of those things. It is BCCI which runs it. But the BCCI, and please understand this, the BCCI is a completely privately owned organization. It is a completely privately owned organization. So, BCCI does not come under state. So, can BCCI violate your fundamental right? Yes, of course it can. It is not state. Understood this? Are we clear on this? Do we understand this? Right? Very interestingly, Amit Shah's son, Jay Shah, is the secretary of BCCI since 2019. The secretary of BCCI since 2019 is the son of Amit Shah, also called Jay Shah. Jay Shah. Yeah, it's true. Okay, understood this? Good. So we've covered the basics. Now I want to do the layout of the fundamental rights. You can take a 5-minute break and then we will start with the layout and we'll finish it before 9 p.m. Chaliye. No, Sugandh. No, Anikesh, it can't be brought to the court for violation of fundamental rights. Yukta, statement 2 is incorrect and statement 3 is incorrect. One only. As I said, domicile means two things. One, similar as citizenship, and also of the state. Now, and you can only have one domicile. Right? Yeah. Yes, Podri, you can. Yes, Amartya, but BCCI practicing untouchability seems a rather far-fetched idea. Now, let's look at an outline of fundamental rights. Let's look at an outline of fundamental rights. Now, you must understand that, of course, there are very extensive fundamental rights and there are several provisions that get into it, but we must only be concerned with a very specific set of fundamental rights, and we'll come to that in a bit. Okay? So, as we know, part 3 is where fundamental rights are. Articles 12 and 13 are explanations to certain characteristics of fundamental rights. Okay? Then your proper fundamental rights start from Article 14 to 32, and then 33 to 35 are certain special provisions which are actually not important. I'll cover them in the full detail. But our primary concern is this. From 12 to 32, this is where questions are asked from. 33 to 35, to a very large extent, is irrelevant as far as exams are concerned. 36 onwards is where directive principles begin. Part 4 begins. Alright, so let us start. Pay attention and as clear attention as you can, because this one sort of write-up is all you need to know for fundamental rights for the prelims. Then we will move to the layer by layer, article by article discussion. But please understand this carefully. So, Article 12 gives you the definition of state. Article 13, and please understand this as clearly as possible, says no law can violate a fundamental right. That means, can a law violate a constitutional right? Absolutely yes. Can a law violate any other legal right? Absolutely yes. But a law cannot violate a fundamental right. That is the basic discussion. A law cannot violate a fundamental right. Can a law violate a constitutional right? Absolutely. There's nothing that says it can't. So what is so special about fundamental rights? There are only a few things. One, that no law can be made in this country which violates a fundamental right. And if your fundamental right is violated, you have a direct access to the Supreme Court. These are the only two things that make fundamental rights special. Otherwise, they can be changed in the same manner as constitutional or statutory rights. They have the same amount of repercussions and so on and so forth. But the only two things which make fundamental rights so special is the fact that you can directly go to the Supreme Court if your fundamental right is violated, and two, no law in this country can violate a fundamental right. These are the only two things which make a fundamental right also fundamental. Then we have certain groups of rights. The first set of groups of rights are rights pertaining to equality. Okay, this is the first set of rights that we will study. These rights are contained from Article 14 to Article 18. And always remember, these rights will be arranged from a broad to a narrow manner. They'll first cover all the dimensions, then they'll go specific, 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 specific. So, Article 14 will be the most general right, then 15, then 16, then 17, then 18. So, Article 14, which is your right to equality, basically talks about two things: equality before law and equal protection of law. This means everybody will be treated equally before the law, and the mic is on, Prashant. Mic is on, mic is perfectly on. Mic is on. ठीक है? So Article 14, equality before law and equal protection of law. Equality before law means everybody will be treated equally before the law, before a court of law. And equal protection of law means treating like people alike, which means everybody can't be treated the same way because everybody comes from different circumstances. Basically saying that people with difficult circumstances should be given some amount of special treatment, right? So for example, if there are some students in the class who are not able to understand and I take an extra class for them to explain some concepts to them in detail, it is not unfair to the rest because I am not teaching them anything additional. I am just teaching them the same thing which you would have also been taught, but you understood in the first go. Now they would have not been able to understand this for whatever reasons, and therefore an extra class or a doubt clearing class or a remedial class has been organized for them. That does not put you at a disadvantage. So that's the basic concept of equal protection of law, and we'll do them in detail. So we are saying because of these two things, the law becomes so important, right? Both of these things is how rule of law exists. And if the law is supreme, then the law must be worthy of being supreme. So we will cover this. We will understand two extremely important concepts: procedure established by law and due process of law. Procedure established by law and due process of law. If everybody has to be treated equally before the law, and if special law can be applied to special people specially, does the law deserve to be so important? Does the law deserve to be bigger than all of us, bigger than the makers of the law, bigger than the citizens? For that, the law must be a good law. For the rule of law to prevail, the law must be a good law. And how is a law a good law? First, it is passed with the right procedure, and two, it is passed with the right intention. If both of these things are valid, then the law is a good law. Procedure established by law is clearly, directly, explicitly mentioned in the Constitution. In fact, Article 21 mentions it. And due process of law is something that has been integrated through various Supreme Court judgments. One of them, of course, is Menka Gandhi, which we will discuss much later. So this is what Article 14 is, the largest interpretation of equality. Then you have Article 15, 16, 17 and 18. So 15 contains two things. First, non-discrimination, and second, education based reservation. So education based reservation. If you notice carefully, equal protection of law says treat like people alike. People with special circumstances must be given special treatment. This is the birthplace of something called affirmative action, that you are trying to do something to make the lives of people who are disadvantaged better. So one can say that Article 14, through equal protection of the law, allows you to reserve, whereas Article 15 tells you how to, Article 16 tells you how to. Article 16 is nothing but employment based reservation. Is nothing but employment based reservation. Okay? Article 17 and Article 18 are very clear. Article 17 is abolition of untouchability, and Article 18 is abolition of titles. Very clear that academic and military titles are allowed, awards are allowed. That's it. They are allowed. No foreign titles of any kind are allowed. Okay. We'll cover rule of law. And in fact, I've covered rule of law in the very first class. So don't worry about it. Go back and revise the first class. Okay, Abhishek? So this is broadly how it is. We will do all of them in detail. Don't worry. But if you look at the broad to narrow composition, what do you understand? That Article 14 is the general overarching provision on equality, that everybody should be treated equally, special people should be treated specially. Then Article 15 narrows it down a bit, that don't discriminate on public places, give education based reservation. Article 16 is give employment based reservation. Article 17 is do not allow untouchability of any kind, even more specific. And something incredibly narrow, in fact outdated in today's times, is do not allow for any non-state titles to exist. It's that simple. That is all that there is. This is Article 14. As long as you understand the broad connotations of this, it is more than enough. Okay? And the UPSC has mostly asked questions from Article 14, has asked questions from 17 and 18. They haven't touched 15 and 16 because I told you the reservation is a slightly tricky issue. Okay? Now, always remember, this is something very important. Untouchability is an issue of equality, not exploitation. People often get confused. Just because somebody is practicing untouchability against someone, that does not mean the person is exploiting somebody else. Untouchability means treating two different classes of people differently in a negative context, differently in an individual capacity. So untouchability actually is a component of equality, not a component of exploitation. There were questions on this in the previous years and people have often marked those questions as wrong. So these are the first set of rights. Then the second set of rights are rights pertaining to freedom. Rights pertaining to freedom. Now this is just under Article 19, right? Now in the prelims you don't need to know the reasonable restrictions and nothing, but if you see the kind of rights that have been given under Article 19, they are also very, very logically arranged. You don't have to really, worry about it too much. Now there were originally 7 freedoms, but today there are only 6 because one of the property related provisions has been removed. So you have Article 19 clause 1 A, B, C, D, E, F does not exist, and then G. So what are the provisions? They are under Article 19 clause 1. Just broadly, there is A, there is B, there is C, there is D, there is E, there is no F, because F pertain to property and we don't have any fundamental right pertaining to property anymore. And then we have G. Okay, so what are these? What are the basic freedoms? Again, broad to narrow. We'll cover them in detail, don't worry. Speech and expression. Speech and expression. Speech is verbal, expression is everything apart from verbal. Movies, OTT, cartoons, paintings, editorials, drawings, comedy, stand-up, everything comes under expression. Press rights, everything. So speech and expression. And it is because of this that through Supreme Court judgments, the right to information has also been declared an implied fundamental right under Article 19. That if I have the freedom to speech and the freedom to expression, and I have the right to have an opinion on the government, then I also have the right to seek the information from the government to have a legitimate opinion on the government. That's extremely important. So speech and expression. अब भाई बोलने की आज़ादी है, अपने आप को एक्सप्रेस करने की आज़ादी है. एंड एक्सप्रेशन इज नॉट जस्ट it's a very deep concept. People express themselves through their gender, through their orientation, through their ideology, through culture, through costume. Expression is a very wide term. We often look at a very narrow interpretation of it, but वो तो है. अच्छा, बोलने की आज़ादी, घूमने की आज़ादी, अब मतलब बोलने की आज़ादी, अपने आप को एक्सप्रेस करने की आज़ादी. Then it also means भाई एक दूसरे से मिलने की आज़ादी, to assemble without arms. बिना कट्टे के मिलेंगे. अब बिना कट्टे के मिलके क्या करेंगे? बिना कट्टे के मिलके we will form associations, we'll form unions, we'll form associations. We can also form very recently cooperative societies added through the 97th amendment later. Okay, right? Then भाई you have the absolute freedom to अब कहीं भी आके आपस में मिल सकते हो. तो भाई इंडिया में कहीं भी घूम सकते हो, मूव फ्रीली. आप कहीं भी घूम सकते हो तो कहीं भी सेटल हो सकते हो. सो यू हैव द फ्रीडम टू रिसाइड इन एनी पार्ट ऑफ द कंट्री. आप कहीं रहोगे तो कहीं काम करोगे. सो द फ्रीडम टू कैरी आउट एनी ट्रेड, बिजनेस और प्रोफेशन. बस. अब इसके हम इंटरप्रिटेशंस पढ़ेंगे. यहाँ से क्या निकल के आएगा? यहाँ से डिसेंट निकल के आएगा. यहाँ से now what happens is when we study this for the mains exam, what does this translate into? When we look at all these, when you look at speech and expression, we look at say dissent related issues, right? We look at dissent related issues. तो उसमें हम hate speech देखते हैं. Then we look at sedition. Then we look at press rights. We look at journalistic rights. Then we also look at, for example, from assemble and without arms to assemble and to form unions. We look at the right to protest. We look at the right to strike. There are so many sub issues that sort of come out of this, right? So of course we will cover this later in a lot of detail. तो वो मीन्स के लिए इम्पोर्टेंट है. प्री के लिए इतना पता है बाबा, बहुत है. कोई नहीं पूछता, कुछ नहीं, कोई नहीं पूछता. मैं आपको दिखाऊंगा ये करके कि कोई क्यों नहीं पूछता. ठीक है. सो दिस इज मोर देन इनफ. तो इक्वालिटी 14 to 18, देन 19 फ्रीडम ऑफ स्पीच. अब अपना तरीका थोड़ा अलग है. ठीक है. व्हाट वी आर गोइंग टू डू इज we are going to look at justice related rights together. Now justice related rights are under article 20 and 22. हम इसको साथ में पढ़ेंगे. We will study them together. Again broad to narrow. So 20 is about the general principles of criminal law and criminal justice. बहुत क्लियर कि ये लॉ लग सकता है नहीं, पनिशमेंट मिल सकती है कि नहीं, द क्रिमिनल लॉ प्रिंसिपल्स. एंड 22 इज नथिंग बट प्रोटेक्शन अगेंस्ट अरेस्ट एंड प्रिवेंटिव डिटेंशन. अरेस्ट मतलब कांड करने के बाद पकड़ा, और कांड करने से पहले हमको लगता था तुम कांड करने वाले हो, तो भाई प्रिवेंटिव डिटेंशन, बस और कुछ है ही नहीं। दैट्स इट, इट्स दैट सिंपल, नथिंग एल्स, नथिंग एल्स। अब वो क्रिमिनल लॉ के प्रिंसिपल्स क्या है कि भाई क्रिमिनल लॉ बैक डेट पे नहीं लग सकता। हम पढ़ेंगे एक ही क्राइम के लिए एक ही पनिशमेंट मिलेगी, वन क्राइम वन पनिशमेंट। इसको मैं फैंसी शब्दों में बोलूंगा प्रिंसिपल ऑफ डबल जेपर्डी। मैं बोलूंगा बैक डेट पे क्राइम नहीं लग सकता, सो आई विल यूज अ फैंसी वर्ड कॉल्ड रेट्रोस्पेक्टिव एप्लीकेशन ऑफ द लॉ। अच्छा लगेगा, अच्छा लगेगा, ठीक है। वन क्राइम वन पनिशमेंट। मैं बोलूंगा कि भाई देखो ऐसा है कि आप किसी को अपने खिलाफ गवाही देने के लिए मजबूर नहीं कर सकते, यू कांट फोर्स एनीवन टू गिव अ स्टेटमेंट अगेंस्ट देमसेल्फ। उसके लिए हम फैंसी वर्ड इस्तेमाल करेंगे, वी विल कॉल इट सेल्फ इंक्रिमिनेशन, सेल्फ इंक्रिमिनेशन। दैट इज वाई कोर्ट में पुलिस की गवाही कभी भी फाइनल नहीं होती, बस इतना ही है, नथिंग एल्स, दैट इज इट। जब ये हो जाएगा then we will move to exploitation related rights. Very simple, exploitation rights उठाएंगे हम। exploitation rights are 23 and 24। भाई again broad to narrow, 23 human trafficking, भाई नहीं कर सकते, ह्यूमन ट्रैफिकिंग, बेगार, फोर्स्ड लेबर अलाउड नहीं है, बस इसका मतलब समझेंगे और कुछ नहीं। एंड 24, human trafficking is for everybody, and 24 is with respect to child labor, that is it, बस broad to narrow। यहाँ पे exploitation खत्म हो गया, बस simple as that, ठीक है। then you have your softer rights, सबसे ज़्यादा इशू यही आता है। then we will look at rights pertaining to religion, और इसमें हम क्या देखेंगे, आर्टिकल्स 25 to 28, अब 25, 26, 27, 28। now each of these rights have very specific principles। अब 25 is an individual's freedom of religion। भाई भगवान को मानना है मानो, नहीं मानना है मत मानो, कन्फेस करना है मानते हो तो ठीक है, बताना चाहते हो तो ठीक है, आप कुछ ताबीज़ पहनना चाहते हो, कलावा पहनना चाहते हो, कैप पहनना चाहते हो, पगड़ी पहनना चाहते हो, पहनो भाई। एंड इफ़ यू वांट टू कन्वर्ट पीपल इनटू योर रिलीजन, फोर्सफुल नहीं होना चाहिए। सो द फ्रीडम टू कॉन्शियंस, प्रोफेस, प्रैक्टिस, प्रोपोगेशन एंड इंडिविजुअल्स फ्रीडम राइट, यही है, दैट इज इट। एंड इंडिविजुअल्स फ्रीडम ऑफ religion, that is it, that is all that article 25 talks to you about। अब उसमें इश्यूज बहुत सारे निकलेंगे, वो बात की बात है, वो हम बाद में डेफिनेटली कवर करेंगे, बट इतना बहुत है, इसके ऊपर कोई कुछ नहीं पूछता है, ठीक है। अब भाई संस्था बनाते हैं लोग, सो यू हैव द फ्रीडम टू मैनेज रिलीजियस अफेयर्स। तुमको एक ऑर्गेनाइजेशन बनानी है, तुमको लैंड लेनी है, तुमको आश्रम बनाना है, तुमको मिशनरी ट्रस्ट बनाना है, बनाओ यार, किसने रोका है, ठीक है। अब बनाओगे, भगवान का काम करोगे तो टैक्स कैसे दोगे भाई। सो टैक्स एग्जेम्पशन है आर्टिकल 27 में, ठीक है, टैक्स एग्जेम्पशन। हमें ज्यादा लोड लेना नहीं है यार इसमें। आई सी पीपल गेट इनटू अननेसेसरी टेक्निकल डिटेल्स, तो इंपॉर्टेंट ही नहीं है, ठीक है। उसके बाद एंड लास्टली हम यहाँ पे कि रिलीजियस इंस्टीट्यूशंस और एजुकेशन को हम समझेंगे। इफ यू रिमेंबर आवर गवर्नेंस क्लास, ये मैंने आपको पढ़ाया हुआ है दैट द स्टेट कैन नॉट इंटरफियर इन द अफेयर्स ऑफ अ रिलीजियस एजुकेशन इंस्टीट्यूशन एंड रिलीजन कैन नॉट बी टॉट इन अ स्टेट एजुकेशन इंस्टीट्यूशन। ये मैंने आपको गवर्नेंस में बहुत क्लियरली पहले एक दो क्लासेस में पढ़ाया था। आई एम श्योर यू वुड रिमेंबर, दोज आर ऑल्सो ऑनलाइन क्लासेस, ठीक है। तो इतना आसान है रिलीजन। अब भाई लोगों को धर्म दे दिया, अब यार there is a lot to life, right? Understood this? Clear? Is Anupam, it's not admitted as direct evidence, इसको कोर्ट में reaffirm करना पड़ता है, बताऊंगा क्यों, ठीक है। Then you have 29 to 30, these are rights of minorities, these are rights of minorities। अब भाई 29 बताएगा माइनॉरिटीज़ क्या होते हैं, 30 बताएगा कि आपके लिए इंस्टीट्यूशनल राइट्स क्या है एज फार एज माइनॉरिटीज़ आर कंसर्न्ड. ठीक है. सो आर्टिकल 29 tells you that you can have any form of minority. You can have a religious minority, you can have a linguistic minority, you can have a cultural minority. It tells you that there is no standard definition of minority, it is relative in nature. And 30 tells you that you can set up institutions to promote what defines you a minority, and the government is going to support those institutions. यहाँ पे reservation वगैरह नहीं लगेगा, बस और कुछ नहीं है. That is it. Okay? Yes? Are we clear on this? Understood? Of course I have taken a governance class, boss. मेरे को कैसे याद नहीं होगी यार, मैंने क्लास नहीं ली है. मैंने लिए, मेरा तो काम है ये. ठीक है, बस दिल से ऑनेस्टली बताओ, कुछ मुश्किल लग रहा है इसमें? Is there anything that you're finding technical or difficult or anything problematic? कुछ भी ऐसा लग रहा है इसमें? बस इतना ही है. बस इतना ही करेंगे, यहां से उठाएंगे, यहां खत्म करेंगे. 31 is related to property and certain provisions on basic structure में करेंगे. 32 is if these are your bullets, 32 is the gun that you put the bullets inside. कि हाँ भाई रेडी है, सुप्रीम कोर्ट जाएंगे, डिस्क्यों डिस्क्यों डिस्क्यों. बस the orders given by the courts to enforce a right is called a writ. अब वो 5 तरह की रिट दे रखी है. आज तक प्री में नहीं पूछा कि किस रिट से क्या होता है, बिकॉज टू अंडरस्टैंड रिट्स एंड टू अंडरस्टैंड द प्रोसीजर्स बिहाइंड द रिट्स, दिस इज वेरी 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 टेक्निकल, वेरी वेरी टेक्निकल. मैं बताऊं क्यों? बिकॉज आम जनता पढ़ती है कॉन्स्टिट्यूशन लक्ष्मीकांत से. एक्चुअल रिट्स प्रोसीजर्स जो मैं पढ़ता हूं, वो मैं पढ़ता हूं मेरी ये 2 किताबें. These are the original, this is the updated, this is the whole constitution in 2 volumes. ठीक है. और इसको हम शॉर्टर कॉन्स्टिट्यूशन कहते हैं. आर्टिकल्स 1 to 151 is in the first volume and 151 here is in the second volume. ठीक है. तो कोई नहीं पूछता है. ठीक है. वो 5 मिनट की क्लास के लिए इतना एफर्ट जाता है. All right, do we understand this? Correct? It's that simple. Yes, बस. We'll start with writs tomorrow, और उसके बाद we'll start line by line. Article 14, Article 15, Article 16, 17, 18, 19. 3 दिन लगेंगे, पूरा theme 3 खत्म, including the mains part of it. All right, understood this? Great, excellent. ठीक है. I can guarantee you, what you can do now is, you can go to the drive, and if you go to the drive and if you just look at the past year questions, okay, that I have uploaded, the past year questions that I have uploaded, including 2021 till 2021, मैं ये लिख के दे रहा हूँ, मैं ये लिख के दे रहा हूँ. राइट? यस. चेतराम, 21 इज लाइफ एंड लिबर्टी. वो तो जान है मेरी भाई, 21 तो जान है मेरी. ऑब्वियसली आर्टिकल 20 और 22 के बाद मैं 21 तो करूंगा ना. जीने की आज़ादी और रहने की आज़ादी, लाइफ एंड पर्सनल लिबर्टी. तो जीने की आज़ादी तो मरने की आज़ादी, यूथेनेशिया करेंगे। पर्सनल लिबर्टी का मतलब जैसे जीना चाहूँ वैसे जीना चाहूँ, वो हम कवर करेंगे, राइट? अंडरस्टूड दिस, राइट? ओके, यस प्रशांत। 21 पे 21 ए ऐड हुआ है, विच इज एजुकेशन। ऑफ कोर्स वील कवर 21, डोंट वरी। ठीक है। चैत्राम पूछ रहा आर्टिकल 21 किधर गया? It's fine to read the older edition of Lakshmikant. बिल्कुल, it's absolutely fine. So this is how we are going to cover. मैं लिख के दे रहा हूँ. Open this file which has previous year questions till 2021. अभी तक जितना पढ़ा है, बिना राइट्स पढ़े, without reading rights, you will be able to solve all the questions from the last 21 years. Okay? Right? शिवेंद्र पूछ रहे हैं विल यू टेक इंपॉर्टेंट जजमेंट साइड बाय साइड? ऑफ कोर्स नॉट, ऑफ कोर्स नॉट। मैं मेंस में जजमेंट्स क्यों कराऊंगा बेटा? मेंस में जजमेंट का क्या करोगे? ऑफ कोर्स भाई, आपने पैसा दिया है, मैं नाचेगा, मैं जरूर कराएगा। राइट? यस, थैंक यू साई। सो try solving the previous year questions tonight and pay absolute attention, pay absolute focus. You'll be able to solve almost all the questions without anything. Acha, no class for you in J batch. They'll give you the class, Ankit. Oh, this is worrying. I thought all the batches were there. Okay, all right. Chalo, done. Thank you. Thank you. Thank you. See you tomorrow. See you tomorrow. है ना? Chalo, done. We've covered this. We'll now start with layer by layer. Sorted. Thank you.